Hey guys, welcome to my legal classes. This is Ganesh Pujari, and after several classes, we have almost completed chapter 1, which is about preliminary aspects. Now it's time for us to log into chapter 2. Chapter 2 is all about relevancy of facts covering from section 5 to 55. But one important aspect that we very clearly should know is what is relevancy and what is admissibility. Now, lot of people get confused, but being legal professions, we need to be very clear on that. So I am bringing two bonus videos. The first one, the relevancy and admissibility, and the second video will be relevancy versus admissibility, or the difference between these two concepts. Hope that helps. With that, I am taking you to the first slide. Here in this video, I am going to explain the meaning of both the terms, and then I am going to give two important case laws, and finally we are understanding what comes first, whether is it relevancy very important or the admissibility. All of them will be covered here. And whenever there is a long question on the difference between relevancy and admissibility, you need to give a brief note on these two concepts, and that way this video becomes an introduction for your differences between relevancy and admissibility. With that much of introduction, I am taking you to the first slide. As usual, first let us try understand the meaning. When it comes to the term relevant, we have already had a detailed discussion on this particular aspect while I was discussing about interpretation clause. The term relevant is when you are discussing about a certain fact in issue. If one fact is connected to another, that becomes relevant to that particular case. Now we already know the meaning of fact also. Again, we have an independent video on facts where we have understood that facts are those which are sensed by a person with using his five senses like hear, see, touch, smell, etc., or one additional sense, that is our sixth sense or the psychological sense, where we make opinion, we feel, etc. Now those are facts. Now chapter 2 from section 5 to section 55, all the sections are dealing with relevancy of facts. These are related to relevancy. The relevant facts are mostly in the discretion of court. Court can allow to do certain fact finding, or it may deny to do certain fact finding. But how exactly the power of court is understood, or what is the power of court, or what is the limitation of court, that we can understand from admissibility. Why the court can agree to do fact finding in most of the relevant fact cases, there are certain limitations also on the court to not to allow any kind of inquiry on certain amount of relevant facts, though they are relevant, because there is a very clear stoppage from the law itself. Now for example, if there is a fact finding in progress and an advocate brings a communication made by one spouse legally wedded to another as an evidence, the court will not admit it, because under Indian Evidence Act it is not admittable evidence. So the power of court to allow an advocate to admit an evidence or not to admit an evidence is admissibility. If the court agrees, then that is admitted. If the court doesn't agree to look about those facts because there is a limitation which is mentioned in the law itself, then they are not admitted, they are non-admissibility. So that is the aspect of admissibility. Why do we need so much of relevancy of facts and admissibility? It is because we have to save the time of the court. We have to discuss only those aspects which are relevant to the case, and then the court will allow only those aspects which are admitted by law. Now, we need to remember that all admissible facts are relevant, but all the relevant facts may not be admissible. For that, I have a detailed list here which are exclusions or which are not admitted by the court. Like section 91 to 99 is the chapter which discusses about exclusion of oral by documentary evidence. Section 115 to 117 discusses about exclusion of evidence of facts by estoppel, and section 121 to 130 discusses about exclusion of privileged communications such as confidential communications with legal advisor, communication during marriage, official communication, etc. If you want me to give few important sections, I would like to give these four sections from which you can quote one or two sections, like section 25, which is confession made to a police officer, or section 89, which is insufficiently stamped document, section 122, communication made by one spouse legally wedded to another, and section 126, professional communications like communication made between advocate and client under certain circumstances, etc. are non-admitted by the court. They are non-admissible evidences. This is what you need to remember. Now I am taking you to two important case laws. The two very important case laws that you should refer whenever there is a question on relevancy and admissibility are Ram Bihari Yadav versus State of Bihar and Lakshman Das Chaganlal Bhatia versus State. In the first case, that is Ram Bihari Yadav versus State of Bihar, the Supreme Court of India observed that more often the expressions relevancy and admissibility are used as synonyms, but their legal implications are distinct and different for more often than not facts which are relevant are not admissible, so also facts which are admissible may not be relevant. So it's basically vice versa. That's what it was held. The then Bombay court in the case law of Lakshman Das Chaganlal Bhatia versus State laid down the following to be relevant facts. What are they? Facts necessary to explain or introduce a fact in issue or relevant fact, facts which support or rebut an inference suggested by a fact in issue or a relevant fact, fact which establish the identity of anything or person whose identity is relevant, facts which fix the time and place at which any fact in issue or relevant fact happened, and facts which show the relation of parties by whom any fact in issue or relevant fact was transacted. These are considered as relevant fact in this particular case law. That is what laid down here. The last part of this presentation, we are trying to understand what comes first. Is it relevancy or admissibility? Now remember, we cannot waste the time of court. So whenever we are discussing about the facts in issues, we need to ensure that they are relevant to the case. Now, based on that relevancy, court may admit certain facts and court may not admit certain facts. Now remember, court has no absolute power to admit or not to admit. The law has guided in certain aspects that court cannot admit. Now when it comes to section 6 to 55, it is relevancy of facts where the court will admit, but there are many provisions, as I have already discussed in my previous slide. They cannot be admissible by the court also. That way, the relevancy of fact is important and first, but then remember, only when there is admissibility is available, these relevant facts are relevant. Otherwise, they are not even discussed. That is how you need to understand. Now, section 136 gives the power to judge to decide as to admissibility of evidence. Here, the judge under section 136 has the right to decide on relevancy and admissibility, and he can question at any time that in what manner such facts are relevant, and the judge would admit the particular presented fact only if he is satisfied with the answer of the party that it is indeed relevant under one or the other provisions given under section 6 to 55. So it is very essential that it stays within the definition of relevant fact as discussed under interpretation clause or as discussed under the Lakshman Das versus state case, and it should be covered in any one of the provision under section 6 to 55. Only then they become relevant fact and then the court can admit. And as I have already discussed in my first slide, there are certain aspects on which the court doesn't have the power to admit. It is very clearly restricted by the law itself. So in conclusion, remember that what is relevant gets admitted, and remember, not all the relevant facts may get chance to get admitted. There can be certain non-admission of relevant facts also based on the provisions of law. Then, though admitted, if not relevant, in that case it is waste of time, and court time is very precious, so we should not waste the court time. Hence, only relevant and admitted facts can be presented. That is the conclusion of this particular presentation, and in my next presentation I am going to discuss the difference between relevancy and admissibility. That's all for the first presentation, and in my next presentation, as I have already told, I will discuss on the difference between these two topics in just one slide. Till then, I'm taking off. Thank you so much for subscribing my channel. Please like, share and comment my videos. All the very best for whatsoever purpose you are referring my channel, and thanks again.